Hello, everybody. My name is Peter Pike. I am a local real estate attorney, and this is FIRPTA for Realtors. And we have a live studio audience who's going to turn the volume all the way down because we don't want any feedback. We're going to be talking about various FIRPTA issues involving real estate. Just so you understand, we're not going to talk about gifts. We are not going to talk about quitclaim deeds. And we're not going to talk about the sale of a real estate option, which also could be considered a disposition under FIRPTA. All right. Additional review should be completed, by the way, if a foreign company or a corporation recently transferred real property to a foreign individual prior to the transaction, as the amount to withhold may be dramatically different. What I'm talking about is sometimes people think, oh, in order to avoid FIRPTA, I will just sell the property from myself. I'll do a deed from me, I'm a foreign person, into my wholly owned LLC. Well, yes, the LLC is now the seller. However, FIRPTA applied to the transaction into that LLC. So it's not like you can just go back and try and make it better. You will have to deal with FIRPTA if, in fact, you are owning it in a foreign entity or you are not a US citizen. Those are the easy ones. By the way, there are other exceptions and we will get to them. If you have any questions, please feel free to put them into the chat. I'll try and watch the chat, and Cassidy said she'll help me out also. In addition to that, if you want, I can send all of you the slide deck. If you would like that, please email me. You've got my email address. It's peter@pikeRelaw.com. PETER@PIKE, R as in real, E as in estate, LAW.com. All right, so let's get started with some of the FIRPTA basics. FIRPTA is the Foreign Investment in Real Property Tax Act of 1980. After June 18th of 1980, foreign sellers of real property are subject to this withholding tax. The withholding requirement began on December 31st of 1984. It was passed to ensure that foreign investors paid their taxes. Rules were changed in 2016, increasing the amounts to be withheld. By the way, the collection of the taxes is technically on the buyer. The buyer is the one by statute who is obligated to collect and pay those taxes. Some states also require withholding of state taxes, but not Florida. Florida doesn't have that type of tax, so we're okay. All sellers of real property situated in the United States or the US Virgin Islands are presumed to be foreign persons. So this applies to all US and US Virgin Islands real estate, and it also applies to installment sales, mines, wells, growing crops, timber or other natural deposits, and rents paid. Technically, if you are not a US resident or US citizen and you own real property here in Florida, in the United States, your tenant is supposed to withhold 30% of the rental payments every month and pay it to the IRS. I don't know anybody who actually does that because most people are not even aware of their obligations to do that. But just so you know, if you are managing real estate for a non-US citizen, you probably should determine whether FIRPTA applies and whether you do in fact need to withhold and pay that money to the IRS. Definitely speak with their accountant. Those are the people who would know. Very important to be careful, make sure you don't get into trouble here. All right, the seller is obligated to file a tax return for all sales of real property in the United States, regardless of the amount withheld, and even if the amount withheld or owed is zero. So remember, this is a withholding tax. Kind of like when you work for an employer and you're getting paid $500 a week, but at the end of the week, your check is $470, $420, whatever it might be. The rest of it is withheld by your employer and paid to the IRS. Is that the amount of tax that you owed? No. Every April 15th, give or take, you file your tax return for the previous year. You show how much you owe in taxes, how much you've already paid in taxes, and most people get a refund because they've overpaid. Same idea with FIRPTA. The withholding is by the buyer. They're supposed to take that money, send it off to the IRS, and then the next April, the seller is supposed to file a tax return showing what they bought the property for. Basically, it's called basis. They need to show what they paid for it, how much they've depreciated it, how much they have put into it, what their cost of the sale were. So basically, you find out what their actual profit is and whatever their taxes are due. And that's usually based upon a tax treaty between the United States and their government. Whatever the taxes that are due, that would come out of the withholding money, the money that we withheld, and the rest of it would go back to the seller. Okay? Everybody clear on that? I hope so. All right. I keep on saying that the buyer is the person who is required to withhold the funds. Generally speaking, the law reads that the buyer is the person who's obligated. Their duties are to determine if the seller is a foreign person. If they are, they must withhold 15% of the amount realized in the transaction. We'll get to what that means in a few minutes. And then remit the amount withheld with the proper forms, we'll get to that too, to the IRS. Usually, it's the closing agent or the settlement offer, whoever does the closing, who takes over these duties. Okay, that's the buyer's obligation, but a third party can voluntarily take over those duties, or a third party might unexpectedly and not on purpose take over those duties. And we're going to talk about that because I don't want you by mistake to become the withholding agent. Okay, usually again, the FIRPTA, the settlement agent, will perform the duties of the withholding agent and become responsible under FIRPTA. What does that mean, responsible? What it means is, in the event the buyer did not withhold that money and pay it to the IRS, and it turns out that the seller owed taxes, the buyer is responsible to pay those taxes up to the 15% that should have been withheld. If a settlement agent, and if we do settlements, law firms, we do settlements, if we take it over, that means that we are obligated to make that tax payment in the event we don't withhold properly and don't give it to the IRS. In the event you, agents, by mistake, decide that you're going to be the FIRPTA withholding agent, you are the ones who are on the hook for all of that money. So be very careful. You don't want to be the withholding agent. Okay, the seller's agent, the listing agent, is also known as the transferor's agent. You can advise them about FIRPTA. You can tell them to go ahead and plan. You can tell them that they need to arrange for this. You can help them with everything, but generally you are not responsible to withhold and remit. You could become responsible if you go past merely giving them the knowledge that they may be subject to FIRPTA and that they need to do things. For example, If you download the forms and help them to fill out the forms, you may now have just become the withholding agent. And if it's not done right, you might be responsible. So please don't download forms for people. Don't help them fill them out. Tell them to go to their accountant. If you don't know somebody, if they don't have an accountant, I'd be happy to tell you of a couple of accountants locally who handle FIRPTA, and they fill out the forms, and it really makes it a lot easier. The buyer's agent, transferee's agent, they can represent, advise, plan, do all that. And the buyer's agent, again, might be responsible to withhold and remit, because if you as the buyer's agent get too involved with the buyer by helping them to fill out the forms, by getting the forms for them, by getting a little bit too involved, you may inadvertently make yourself the withholding agent. Be very careful. Yes, absolutely advise them that they may have to take care of this. Yes, refer them to an attorney or an accountant. No problem with that at all. But do not go much further than that. Don't tell them how much. Don't get into all of that, because you might inadvertently make yourself the withholding agent. Okay. The general rule is that FIRPTA requires the buyer to withhold 15% of the amount realized from the property sold by a foreign seller and remit it to the IRS shortly after sale. The amount realized equals the cash paid plus the fair market value of any other property transferred, plus the amount of liabilities to which the property was subject prior to the conveyance that exceeds the amounts noted above. And by that, I'm talking about short sales. God forbid we have to get back into doing those things, but I have a feeling they may start coming back around for a little while. I think everybody is aware that we have had a moratorium on foreclosures for about a year. That means that there's about a year's worth of foreclosures that are backlogged and are going to start proceeding. It does not mean that we're going to see another crash in the market. Please don't expect that. Right now, our market is, well, it's not healthy because we don't have enough sellers, but it is healthy in terms of the buyers of property are actual end users. It's not speculation. This is not people just flipping properties to each other. This is very real. We will probably see an uptick in foreclosures, which would mean an uptick in short sales. And if you have a foreign seller who is short selling property, it's not necessarily the purchase price, it's the amount that they owe on the mortgage. So if they owe $350,000 and they're only selling for $250,000, the withholding is based on the $350,000, just so you know. Again, don't get involved with that part of it. Just make sure they're aware that FIRPTA exists and have them speak to a real estate attorney who understands this, or to their accountant, okay? All right. A foreign seller includes people who are not US citizens or resident aliens. So if somebody has a green card, they are not subject to FIRPTA. If you are a US citizen, you're not subject to FIRPTA. Any corporations that are organized outside the United States, okay, and any non-resident estates and trusts would be subject to FIRPTA. So for example, if I'm a US citizen, but I form a corporation offshore to own real estate for whatever reason, it is possible, if that offshore real estate is a taxpayer. What does that mean? That means that my corporation is not an S corporation, it's a C corporation. In other words, the corporation is responsible for any taxes that may be due on any profits it earns. then when it pays the money to me as dividends, I get to pay taxes too, as opposed to an S corporation where the tax liability flows directly from the corporation to me. So whether I take the money out of the company at the end of the year or not, doesn't matter. I am responsible for all the taxes that are due on any profits to the corporation. We look at who is the actual taxpayer to determine whether or not FIRPTA applies. So if I have a foreign corporation that effectively is not the taxpayer, it's what's called a non-recognized entity, and I'm the one who's responsible for all the taxes, even though it is a foreign corporation, it's not subject to FIRPTA because I'm a US citizen. Turn it around. If I am a foreign person, I'm a Canadian. By the way, Canada does count as a foreign country, despite what many of us actually think. All right. So if I'm Canadian and I form a United States corporation or LLC to own this real estate, so far so good, but I don't want to have to file tax returns every year for that corporation because I'm going to be renting the property out and then I've got to show the income and it's a pain in the neck. So I'm going to make it a subchapter S, or I'm going to make it taxed as a partnership. What that means is I personally am the taxpayer. Remember, I'm a Canadian citizen, and therefore FIRPTA would apply even though the company is a US company. Very complicated, I know. And that's why it's important for you to just be aware of these issues and make sure that someone who understands them gets involved as early as possible. So a foreign seller, again, does not include residents, aliens. Those are people with the green cards. And there are other very detailed exceptions as to who would not be a foreign seller. It's very rare that you see this. I've been doing real estate law for 35 years. I've had one situation where I had somebody who had extensive contacts in the US. And I'm not even going to go into it because I don't want you to even think about it. I'd rather you make sure that their accountant says, no, they're not responsible. But he said, no, my accountant will tell you I'm really not. And I got a letter from the accountant and I was good with that. But it is very rare that you see that. It's way beyond the scope of this seminar. So we'll go over what you need to do regarding people who you're worried about in the next slide. Okay, again, we talked about who the person is the taxpayer. So you need to watch out for who are the actual taxpayers. So first thing is, how do you know whether or not someone is not a US citizen? You don't. Should you be going to every single one of yourselves and say, well, I'm sorry, I'm going to be a little bit nosy, but are you a US citizen? Probably not the best of things to do. It's not a very good idea. You'll probably get people a little bit upset with you. But what you can do is pull up their tax bill. If the tax bill is going to, for example, Canada, it is very likely that they are not US citizens. So when you do your dog and pony show to try and get the listing, part of it should be, oh, I did some research. I see that you are in Canada. That's where your tax bills go. Just want to know, do you know whether you are responsible for FIRPTA, the Foreign Investment in Real Property Tax Act? They're probably going to just say, yeah, I don't know what you're talking about. But if you say to them, well, maybe your accountant spoke to you or somebody spoke to you and said, when you sell the house, you may have to pay taxes and you're subject to US taxes. Have some kind of a script. I recommend saying something like, I just want to make sure that you are fully protected when you sell. Are you aware of the Foreign Investment in Real Property Tax Act? If you're not a US citizen or if you do not have a green card, the settlement agent will have to withhold 15% of the purchase price and pay it to the IRS. Do you know if this applies to you? So something like that gives you the opportunity to ask in a nice way someone who you may be because of their taxes. Maybe you're talking to them and you're contacting them in a foreign country. Whatever it might be, it gives you the opportunity to open up the discussion. Also, usually they know. They may not know what FIRPTA is. They may not understand when you say Foreign Investment in Real Property Tax Act, but when you say withhold 15%, did your accountant talk to you about that? I found better than 90% of the people are aware of it and actually are prepared for it and are getting ready for it. And that's great news. If they do have an accountant who's working on it, in addition to getting the listing, get the accountant's name and contact information just to make sure that everything is moving forward, because the accountant will need a copy of the contract as soon as it's signed. Okay. Again, what do? You have them contact their tax advisor or a knowledgeable real estate attorney, or if they don't have either one, refer them to someone. All right. Again, be very careful how much you help them with the issues. Informing them of the issue, no problem. Referring them to a tax advisor, no problem at all. Referring them to somebody local who you know, not a problem at all. However, getting the forms and helping them fill them out, that is not acceptable. Do not do that. You may wind up A, practicing law without a license, B, practicing accountancy without a license, or C, becoming the withholding agent, and if it's not done properly, becoming responsible to pay up to that 15%, which I don't think you want to have to do, okay? All right, now there are some exceptions to FIRPTA. Oh, sorry, forgot to click. Don't forget to give them the advice about FIRPTA. Okay, don't give them special advice. All right, most people are aware of what is called the $300,000 exception. That means that if the house is being sold for not more than $300,000 and the buyer intends to use the property as their home or a home, and the buyer has definite plans to reside at the property at least half of the number of days that the property is used by any person during each of the first 2 12-month periods following the date of transfer, then FIRPTA withholding is not required. Okay, that was a lot, so let's break that down. All right, 1, $300,000 or less. 2, the buyer is planning on using it for themselves. Okay, it has to be them or their immediate family, wife, children, parents, but if it goes much further out, it could be a problem. They have to be occupying the property at least half the time that it is being used over the next 2 years. So if during year 1, they come down and they're snowbirding and they're here for 6 months, and then they leave and they rent the property out for 4 months, so far so good. But then year 2, COVID hits, they can't travel down here and they decide to rent it out for the entire year. They have not met the requirements for FIRPTA. Now, the law is that they have definite plans to do this. I'm not going to tell you what that really means. I don't know how the IRS interprets it. I do know that if the IRS decides to audit, and it turns out that there was that problem during those 2 years, whether or not your buyer wins in court is not going to help, because even if they win, their costs of defending an audit and being audited by the IRS are horrible. It says the exception for owner occupied can be any amount. No, it has to be $300,000 or less. All right. Now, there's another situation, since Cindy asked this question, let me get into that as well. That is, if you are selling the house for $1 million or less, and all of these things apply again, then the withholding amount is only 10%, not 15%. Now, here's the thing that we need to understand about all of this. The buyer must sign a certification, which is under penalty of perjury, that they meet the requirements of the exception. So the buyer is now saying, yes, I have definite plans to live in this property at least half the time that it is occupied over the next 2 years. For each of the next 2 years, okay? Even if it's occupied more than half the time, they live there for the first year, the entire year. They spend another week the next year, and then they rent it out for the remainder of the year. It's not half of the time during each of the first 2 years. It's got to be, more than 6 months year one and more than 6 months year two. Okay. By the way, the days that the house is vacant do not count towards the days of use. So, for example, if they live there for 3 months, they leave it vacant for 4 or 5 months or 6 months or 7 months, and then they just rent it out for 2 more, that would be acceptable. All right. Now, remember, I said the big thing here is the buyer must sign a certification under penalties of perjury that they meet the requirements of this exemption. The bad news is that the buyer could be liable for everything in the event that the exemption really does not apply. There is no benefit to a buyer to agree to sign this certification. There's substantial exposure for a liability to the buyer. If the buyer or his family does not occupy the property for half the time that's in use, the buyer can be liable for the tax not withheld, plus penalties and interest. To avoid liability, the buyer must demonstrate a change of circumstances that the buyer could not have reasonably foreseen or anticipated, which caused the change of plans. Again, I don't think you'd have many Facebook likes if your buyer had to do this because you allowed them to sign the certification, meaning they had to go to the IRS and prove that we're demonstrating a change of circumstances, because again, you don't want to have to prove anything to the IRS. They are, well, the people I'm sure are nice, but the organization is not nice. They are there to collect as much money as they can. Because there's really no benefit to the buyer and potential substantial exposure for liability to the buyer, most attorneys I know will never recommend to their clients that they sign the FIRPTA certification. I have a little bit of a different mind frame. The general rule is I tell people not to do it because, again, there's no real upside for them. However, in an example where a buyer is positive that there's no way that this could be occupied by anybody during the next 2 years other than an owner, for example, in a 55 and older community that does not allow leasing out the property for the first 2 years of ownership, or any property that does not allow leasing of the property out for the first 2 years of ownership. Well, that way I can feel at least comfortable explaining to them what the situation is and saying to them, look, you're not allowed to do these things. So in all likelihood, you will meet these requirements. And if you feel that you want to do this, you can. Now, why do sellers want the buyer to do this? Why they want them to sign these certifications? Well, first of all, there are some foreign sellers who don't plan on paying those taxes no matter what. I know of some listings that were a few years ago where it was a seller who was a citizen of another country, not Canada, a citizen of a country where if your money got over to that country, you were never seeing it again, no matter what, because the US is not getting that money back. And basically they said, we're only selling to people who are willing to sign the certification. We are not going to sell to anybody else. Well, because they weren't planning on paying the taxes. I don't know whether those buyers did or did not have a problem. I was asked to tell a buyer, oh, it's okay to sign the certification. I was not comfortable doing it for several reasons. Now, let me give you the overall everything. First, I love my country, but I am not what you would call a patriot. I recognize that my country makes mistakes. I'm willing to say that some things are wrong. So I'm not rah-rah anything that way. By the same token, I want everybody who owes taxes to our government to pay them so that my taxes are as low as possible. And if these people are not going to pay the taxes that are owed to our government, who do you think is going to make it up? Us. And that's why I would prefer to know that those taxes are actually being paid. That's just me, so you know. All right. If the buyer, remember, if the buyer or his family do not occupy the premises for 50% or more of the time it's in use, the buyer can be liable for the tax not withheld, penalties, and interest. And in order to remove that liability, they have to show a change of circumstances that the buyer could not have reasonably foreseen or anticipated, which caused the change of plans. So it's a dangerous thing for a buyer to go ahead and do that, just so you know. By the way, the old, I think it was still CRISP, it might have been FAR, that's how old it is. There was a FAR form that was the certification for the buyer to sign that agents had buyers sign as part of the contract. Do not go looking for that form. FAR stopped it very quickly after a few months when somebody pointed out that by doing that, agents are probably practicing law without a license in advising their clients to sign the certification. Don't do that. Do not advise them to sign or not to sign. You certainly can say to them, hey, the seller has asked you to do something so they can not have to have this money withheld. And I recommend that you speak to a knowledgeable real estate attorney or an accountant before doing it. And by the way, just so you know, if somebody calls me and says, I've been asked to do this, should I do it? Whether I'm involved in the transaction or not, I will talk to them. You know, it's a 5-minute phone call. Explain to them the situation, and I'm not charging for something like that. And I believe most real estate attorneys have the same type of thing. So don't be afraid to ask your favorite real estate attorney to, you know, help out with something like this. I know I'm always willing to do it, and I know several others who definitely do that. Please make sure you reach out to somebody so that you don't get into trouble. Okay, now, one thing that a foreign seller can do is reduce the amount necessary to withhold by applying for and obtaining what's called a withholding certificate. Okay, basically what this means is they're filing a tax return early, showing the profit they're making from the sale of the property, calculating the actual taxes that are due, and in most cases, it's going to be significantly less than the 15% purchase price. I always strongly recommend that foreign sellers get started with this process as soon as possible. Prior to COVID, it could take up to 3 months from the date of filing to get a withholding certificate back. Now it's taking even longer. However, what that means for the seller is, okay, that the withholding money will still be withheld by the settlement agent because we don't know how much has to be paid. But once we get that withholding certificate back, we can pay the IRS what is owed to the IRS, and the rest will go to the seller. So that also brings up, when is the sale going to take place? Okay. If the sale is going to take place in December of a year, in all likelihood, that seller is much better off not filing the withholding for a withholding certificate and just filing their taxes, in February or March once the forms are available, and they'll get their refund fairly quickly after April 15th. Again, if they're selling the house in early January, well, that's pretty easy. Odds are you're going to have that withholding certificate back long before the following April 15th. Again, something to think about that people need to be aware of, and they should make a decision after speaking with an attorney or their accountant. Okay, now the withholding certification can be issued if the IRS determines the withholding certificate is appropriate due to the required withholding amount being more than the maximum tax liability. In other words, the amount that they owe is less than that 15%. Withholding of the reduced amount would not jeopardize the collection of taxes owed, or possibly the realized gain is exempt from United States tax, or the seller or buyer enters into an agreement for payment of tax and provides security for tax liability. Again, these are just things for you to know. It's not something for you to do, okay? It's something, though, that their tax advisor, their accountant who files those forms, can discuss with them to determine what is the best thing for them to do. If they're going to apply for a withholding certificate, they need to fill out Form 8288B. You may have to also apply for a tax identification number. Foreign people do not have Social Security numbers, or at least they usually don't. If they've never gone ahead and filed any tax returns here in the US, they probably do not have a tax identification number. So effectively, they will need to apply both for a tax ID number and the withholding certificate. They can do it at the same time, but the application for the withholding certificate will not be evaluated, until the tax ID number application is submitted. Now, these applications can be made by the seller, the buyer, or someone's agent. The application should be sent in as soon as the contract is signed. It has to be sent in no later than the closing date. In other words, the request for the withholding certificate must be postmarked no later than the date of transfer. If they go ahead and request a withholding certificate after the date of transfer, it's too late. The buyer is obligated to pay that 15% to the IRS. And when I say the buyer, I really mean the settlement agent, okay? I work with a number of local accountants here. And if they tell me, yes, we've gone ahead and we've applied and we're doing it right, I know I can trust them. And I'm willing to withhold that money, keep it in my escrow account, even though I'm liable for any penalties or interest, knowing that they will get me the documentation in enough time to be able to make payments, okay? I will get to that in a few minutes, because payment has to be made within 20 days, all right? All right, so they usually process 90 to 120 days it takes to get back a withholding certificate. Nowadays, 6 months, 9 months, I don't know. Talk to your favorite local real estate accountant. It's changing only because of COVID. The IRS is very understaffed and is having a hard time getting these things out, okay? If the application, again, is made after the closing, after the conveyance, after the transfer has taken place, the IRS will not approve it and will advise the applicant to apply for an early or normal refund. In other words, seller, you got to pay that full 15% and just try and get a refund, that's all. All right. If the withholding certificate is received prior to closing, highly unlikely nowadays. Previously, before COVID, there were times when I would get the withholding certificate prior to closing. That means that the buyer or settlement agent must send in the money to the IRS within 20 days from the date of transfer, the date of conveyance, closing date. All right, you send in the amount on the withholding certificate to the IRS together with a copy of the withholding certificate, the Form 8288 and Form 8288A. Those all get sent in and you're done. If there is no withholding certificate, then I withhold the 15% and I file a different form with the IRS within 20 days with all of the money so that it gets properly taken care of, okay? You don't want to play around with that. You, again, should not be taking care of the remittance. You should not be taking care of filling out the forms unless you are an accountant or you are comfortable with all of this. And I don't know why you would want to take on that responsibility, just so you know. All right, if the withholding certificate or denial letter is not received by closing, then in that case, you withhold the amount in escrow, either 10% if the buyer signed that certification, or the 15% if there's no certification. And after receiving the IRS response, then the withholding certificate is received. You remit within 20 days from the date that the withholding certificate was issued. So we understand what we're talking about. The withholding certificate could be issued today in Washington, D.C. It is sent by snail mail to the accountant or whoever filed those forms, who gets it 3, 4, 5, 6, 7 days later. Which means now there's only 2 weeks or less in which to send out the money. By the way, this is why I will only hold the money in my escrow account when working with an accountant that I know and I feel I can trust. If it's not an accountant that I know, what I usually will do is say to them, tell you what, you're handling all of this, you become the withholding agent, and I'll send you the money to hold in your trust account. And that way, everybody can be safe and the seller can be happy. Sometimes the accountants say yes, sometimes they say no, but just so you know, that's, I want to protect myself. You need to protect yourselves as well. All right. If you get a denial letter, sometimes the IRS says, nope, we're not going to let you do this withholding certificate. You've got to pay the full 15%. Again, within 20 days from the date of the denial letter, not the date that they tell me, the date that that letter is issued, I need to send that 15% into the IRS together with a copy of the denial letter, the Form 8288 and Form 8288A, copies A and B. Again, I will do this with an accounting firm that I know and I trust who is going to get me the documents in time so that I don't have a problem. Because if I send it in late, I'm responsible for the penalties and interest. And quite frankly, I don't want to have to pay that money. So that's why usually it's very good to make sure that whoever's doing the closing is well aware of who's handling the FIRPTA withholding certificate paperwork, that they work together, they talk together, that they communicate, and they make sure that things get done properly. I just had 2 FIRPTA transactions back to back. One was with an accounting firm that I know very well, had no problems with them, and they are in the process of waiting for the paperwork to come in for the withholding certificate. Bye, Bruce, thank you. But the other one was with an accountant that I really was not familiar with. I didn't know them. I was not very comfortable. And I said to them, look, if you want, you hold the money. You know, you become the withholding agent, and I'm all good with that. Apparently, either they or their client was not good with it. So they decided to just have me send the 15% directly to the IRS, and they filled out the forms they needed to do to send those in. It depends on who you're dealing with, just so you realize. Okay. Believe it or not, we are almost done because we're going through this really fast. If the principal reason for applying for a withholding certificate is to merely delay the payment of the 15%, then the withholding agent or transferee, the buyer, could be subject to interest and penalties beginning on the 21st day after the transaction. Again, another reason why I will only withhold and not pay based upon my working with an accounting firm that I know. All right, I don't want to take those chances. You should not take those chances, and quite frankly, you should not expect any settlement agents to take those chances, because it's a problem. It's a very, very real, significant problem. So, what is your best practice? Best practice is to get their tax advisor involved as soon as possible. When you are doing your dog and pony show to get the listing agreement, make sure you've looked up and seen, you know, oh, I see the taxes are going to a foreign country. Are you US citizens? Or if you are speaking to them on WhatsApp because it's a call to a foreign country, recognize that and say, you know, just in case, I wanted to know, you know, do you know about FIRPTA? Use your words. If you would like, by the way, for me to send you what I recommend, that little, you know, the 4 or 5 sentences that I've written up, email me. I'll be happy to send it to you so that you can open up the dialogue and find out. The best thing is to refer your customer to your favorite real estate attorney or accountant so they can get the advice they need. One last FIRPTA horror story that I lived with, and this is why I take it very seriously. I had a client who is Israeli, and her daughter is a realtor here in town, and her daughter referred the closing to me and said, Peter, don't worry. The buyer has definitely said he's going to sign that he intends to occupy the premises. We don't have to worry about withholding certificates. We're good. It's like, okay, as long as you're sure, that's fine. The buyer shows up to closing, and his mortgage that he got seemed a little bit strange for an owner-occupied residence. It was high interest, there was a balloon, you know, it just, something was wrong. And included in my package was a statement from the buyer that this was not going to be an owner-occupied property, that he intended to rent it out. Turns out he was doing this as a commercial transaction. Commercial transactions are not exempt from FIRPTA. In fact, you cannot even use the $300,000 exemption on a commercial transaction. So now I was stuck with either he goes ahead and gets this loan and swears to the lender that I'm not going to live at the property, or we do this as though he signs my certification, which swears he intends to occupy. Obviously, both of them were not true. I don't know why the buyer's agent didn't understand that we had a problem, but he just didn't want to believe we had a problem. I said, he can't sign both of them. He's like, why not? I said, because one of them's a lie. I can't allow him to lie on these documents. And what happened was we had to withhold the 15%, pay it to the IRS. My friend wasn't happy about this, nor was her mother, because now they had to wait over a year to get back the money because she really owed very, very little in taxes. So again, another reason why not to count on that. It can get a little bit ugly. Well, if anybody has any questions, I will be happy to take them at this point. That's everything that you as realtors should need to know about FIRPTA. If you have any additional questions, please feel free to contact me, Peter at PikeRELaw.com. My phone number is 941-312-2580. And I'll stay on here and see if anybody has any questions to put up in the chat. Otherwise, thank you very much. Cassidy, back to you. Oh, wait, I have a question. I know I am going to have a buyer from outside the US. What are the best things I can do for them in advance? Great question. Best thing you can do for them in advance is say to them, hold on, I'm going to go back to my notes and certainly email me and I'll send you this little script. All right. What you want to say to them is, where are my notes? Say to them, I just want to make sure you are fully protected when you sell. Are you aware of the Foreign Investment in Real Property Tax Act? If you are not a US citizen or do not have a green card, the settlement agent will have to withhold 15% of the purchase price and pay it to the IRS. Do you know whether this applies to you? That would be how I would open up the dialogue. And if they say, no, I don't know, you say, do you have an accountant who handles your taxes here in the US? And if they say no, you say, well, I can refer you to somebody who does exactly this type of work if you would like, because you want to get working on it as soon as possible so that you don't have to lose, well, you don't lose it, but you don't have to have 15% of the purchase price withheld. That's the best things that you can do for them. Another question was, do all green card holders have a social security number? I'm not I don't do that type of law. So I am not positive, but my understanding is, yes, they do. If you have a green card, you're allowed to live here and you are supposed to file your taxes every year. So I would assume that they have, if it's not a social security number, it is some form of tax ID number. So I believe, yes, they do have that number. And let's see, what was my phone number again, please? It's 941-312-2580. You can look me up on Google, Peter Pike Lawyer in Sarasota. I have a website. You can find all of my information there as well. Any other questions? All right. Cassidy, I think we're back to you.
All right, Peter. Well, I think that's it. Thank you so much for being here and teaching this class today. I really appreciate it. And I think everybody really enjoyed it from the comments I'm seeing. So thank you so much. And I think we're all set.